Don't talk to him. Court calls the case, People versus Thomas Styron.
I'm Stein, the living man. I'm here by special appearance to address this matter.
I'm sorry?
So I'm Thomas Styron, the living man, not Thomas Ulrich Styron, the entity you know me as, or as I'm in the papers. I'm here to address the matter.
All right, thank you. Wish to be represented by an attorney, sir?
No, I'm here to address the appropriate persona.
All right. I do have to advise, so you're gonna represent, you need to stand in the middle of the podium where he's telling you to stand. Now. Mr. Allen. If you don't want to cooperate and handle things, he wanted you in the middle of the podium where you're supposed to be. If you don't want to be there, then say no. I'm telling you now to do it.
If you want me to stand close to the mic, no problem.
Sir, you want to play a game with me?
No.
Not today. Mr. Allen, take him. We'll bring him back out when he wants to cooperate. Yeah, I need an interpreter for the last two and that one.
May I swear the interpreter?
Yes, is it for the last two cases?
Yes.
Yeah, that one we'll swear in.
Your interpreter, you're in front of the Honorable J. Cedric Simpson out of the 14th District Court of Washington County, State of Michigan. Our number is 1.
Get somebody from security to check back there.
She's got a shirt on. So I'll take it up. So I'll deal with him. I'll take the cuffs off. Get it out.
I don't know that we're gonna be doing all that, but let me ask you something. On the Styron matter, I sent my bailiff back to get him to bring him back out. The court is of the understanding that defendant number one is being, I will say, uncooperative, has purposely done some things to make it difficult to bring him out. What I'm going to do at this point in time, we're not going to wait and not going to play his game. We will hear him next week because of his behavior today before the court. At this point, I will revoke his bond.
Let's pause right here. This is a critical legal turning point. The judge has just revoked the defendant's bond, which is a serious move. Why? Because courtroom behavior matters. When a defendant is labeled uncooperative, it signals risk of noncompliance, disruption, or even failure to appear. And in legal terms, that's enough for a judge to pull bond privileges immediately. Now think about this. Instead of progressing his case, the defendant's actions just delayed it and made his situation worse. Was this a strategic move or a complete miscalculation? Drop your thoughts below. Should the judge have given him another chance, or was this the right call?
And I will adjourn the probable cause conference. He certainly poses a risk to even bring him out. So I will adjourn this out to May 2nd, 2024, 9 a.m. or as the invite indicates. I will leave it there for the reasons that I've stated on the record. Mr. Mansour, he is not represented by counsel. If you would, for the court, take the opportunity to go back and to apprise him that of what the court has done and that I will see him next week. The court feeling that he's being uncooperative and not compliant. All right. Thank you.
Thank you, Your Honor.
Thank you. Court does call the case, People versus Tariq Day.
I am Tariq Samar Tariq Day, the executor of the Tariq Samar Tariq Day Living Trust and the registered owner of the Tariq Samar Tariq Day Ex Relatione Kingdom Wilson Estate.
Right. So you are appearing here without an attorney. I do have to advise you that you are charged with the offense of fleeing and eluding in the third degree under the Motor Vehicle Code. That is a felony punishable by up to 5 years incarceration and or $1,000 fine plus court costs. Additionally, the Secretary of State could suspend your driving privileges for up to a year. Do you understand that, sir?
I comprehend.
Do you understand?
I comprehend, yes.
The court has to further advise you that if you wish to be represented by counsel, the court would ensure that counsel would be appointed to represent you in this matter, and that you would have counsel if you could not afford to hire counsel yourself. I also wish to advise you that the court would be treating you the same as it would the people in this case. There are certain dangers to representing yourself in this matter, in that you will be required to abide by the Michigan court rules, the Michigan rules of evidence, and all of the cases and statutory requirements. You understand that?
I do not.
You do not. What is it about that you do not understand?
It's against my religion to adhere or to assimilate to any statutory.
Sir, I'm not asking anything about your religion. It is irrelevant to me. I am indicating that in this proceeding, you will be required to abide by the rules of this court. Do you understand that?
I'm having a hard time understanding why or how religion doesn't play a role. If
How what?
how religion does not play a role.
Religion does not play a role in what I do or what this court does. There are certain rules of this court established by the legislature and the Michigan Supreme Court regarding how these particular proceedings will be conducted. These proceedings will be conducted in accord with those rules. Do you understand that, sir?
Well, according to the American Declaration on the Rights of Indigenous Peoples, as well as the international or the United Nations Declaration on the Rights of Indigenous Peoples, the state and the governments should.
Sir, you have no authority for what you're about to state, because what you're about to state is incorrect.
Oh, I am an Indigenous person.
No,
so I do have.
sir, what you're about to state is incorrect.
Well,
If you were on indigenous lands, if that's where you're going, then maybe you might be right. As it stands right now, this proceeding is not on indigenous land.
well, that's a matter of perspective, sir.
It is, and the only perspective that's going to matter on that is mine. We are not on indigenous lands subject to indigenous or tribal rules.
Is there
You
a
are
law?
subject to the rules of the Michigan Supreme Court as they are promulgated, both in terms of procedure and evidence. Do you understand that that's what's happening, sir?
I do not.
What is it that you do not understand?
I don't understand.
Because I'm going to tell you something, sir. If you are unable to establish or understand what I'm saying, and go through this with you again, I have to assume that there may be some reason why you don't understand. This court will take precautions to protect your rights, and I will be sending you for a competency evaluation to make sure that you are competent to stand trial and to stand in these proceedings.
Well, I would agree to a competency if the prosecution as well as the court and the officers agree to take a competency.
That's not the way it works. You don't get to make the rules.
I'm not.
I'm ordering a competency.
I'm not making.
Defendant is ordered for a forensic evaluation. I will set a competency hearing in this matter for July 25th, 2024. At what time? At 9 a.m. Now, sir, I'm going to ask you this.
Yes, sir.
because it's going to depend on where you may be staying for a period of time. If they send you information as to when you have your forensic interview,
Yes, sir.
are you going to cooperate and attend that interview?
Under threat, duress, and coercion, yes.
Pardon?
Under threat, duress, and coercion, yes.
No. It's not how it works.
I don't.
I'm asking you, are you voluntarily going to cooperate?
I say yes.
Pardon?
I mean, under it, yeah. I mean, is this what are, excuse me, what are you relaying to in regard? What are you insinuating in regards to where I will stay for a time?
I'm going to make sure that we are going to have our forensic interview done. I've ordered a forensic interview. I am asking you whether or not, when given notice of that interview, whether or not you are going to voluntarily cooperate in that interview.
I will take the interview.
Excuse me?
I will take the interview.
Anything from the people?
Would the court ask the people to prepare the order for the competency?
Yes, please prepare the order for the competency if you would, sir.
And the address for,
The defendant,
I see on the complaint is 14.
is that your address, sir?
Excuse me? Yeah, that's correct.
All right, very good.
And so I will send a copy to that address.
Very good. All right. This time then bond is continued.
Yes, sir. And I'm sorry, can I get that date again, please, sir? If I can put it in my calendar.
July 25th, you were supposed to, so I'm assuming you're waiving it. You were supposed to file your motion with.
I
the
did.
court.
I filed it.
When did you file it?
I brought it in today.
Do we have it?
I gave it, I mean, it was stamped and everything. I gave it to the reception.
Why didn't you file it before today?
Well, as I stated at the last hearing,
No, don't go through what you
additional week.
stated at the last hearing.
Well, you
You
asked.
knew that, no, you knew it was supposed to be filed before the day. Young man, you're gonna
That's it.
figure out something. We're playing by my rules, not yours. So you do not say anything because you're gonna figure that out real soon. Do they have it?
I have not received a response yet.
Since I'm sending in for a competency, I can't hear that. I can't hear his motion in any event. So I won't hear his motion at this time. He'll have to refile it timely if he's determined to be competent. So I'll have his bond continue. He can go.
I
What?
didn't get the last part that you said. The bond continued and what?
I said you can go.
Oh, okay, no problem.
Is that it for me? Thank you, Ann. Thank you, Alan. Thank you, Em. 14.
This case is a perfect example of what happens when courtroom procedure clashes with personal ideology. Across both defendants, we saw repeated attempts to challenge legal authority, whether by rejecting identity, invoking religion, or citing international declarations that simply don't apply in this jurisdiction. From a legal standpoint, the judge stayed consistent, enforce the rules, maintain order, and protect the integrity of the process. One defendant lost bond due to non-cooperation, while the other is now facing a competency evaluation, which could significantly impact how the case proceeds. The bigger takeaway? In court, understanding and following procedure isn't optional, it's essential. No matter your beliefs, the courtroom operates under established law. Backhand index pointing right now, we want to hear from you. Who do you think handled this situation better? The judge or the defendants? Were these arguments valid or completely off track? Fire if you found this case as shocking as we did. Make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.